Mr. Mann, I don't know if you wanted to be heard or
Our 119 issues are handled by the Chief Assistant, Mr. Gross.
Your Honor, for purpose of the record, my name is William C. Bose, Assistant State Attorney. Basically, Your Honor, I have a case that I think is somewhat illustrative, and if I can approach and give the court Times Publishing Company versus State of Florida, which is a fairly recent case, basically lays out the law. It seems, well, first of all, and I know Your Honor is familiar with this, but I think it's really important that we remember again what a public record is. And by paraphrasing the statute, 119.011 sub, well, it's 11, basically, and it defines public records, and paraphrasing it, it's everything we receive in the course of business, unless there's an exemption. The court in the Times case basically lays out in black letter law that says once criminal investigative or intelligence information is disclosed by the state to a criminal defendant, that information becomes non-exempt public record subject to disclosure pursuant to statute on inspection of public records. The court goes on to talk about that there are some exceptions and that the defendant has the right to ask Your Honor to restrict disclosure of it if it is going to inhibit the defendant's right to a fair trial. But that only a non-party can ask you to not release something that would defame them or threaten their safety, etc. Your Honor, we're, I guess, the best position to say that we don't have a dog in this fight. We have disclosed everything we have disclosed because we are required by law to disclose it. And if Your Honor would tell us not to disclose anything more, we would not disclose anything more. We have no desire to give it out. However, once we heard this motion was being filed, we stopped dissemination to let Your Honor make whatever test you feel is appropriate. We have no position on whether Your Honor should grant or deny this. However, if you remember in the past, we have moved you to ask you to restrict certain disclosures and comments. And so any disclosures that would give this defendant a fair trial, we're certainly in favor of because that's what our goal is.
Rachel Fegan on behalf of the Sentinel. Thank you, Your Honor. And I would like just to correct, the Orlando Sentinel has copied many photos from the Photobucket page. Just because they haven't published them doesn't mean they don't have them. My clients informed me that they have. Now, is that every photo that's in discovery? I don't know because I don't know which photos they are. But my client has informed me that they did go to Photobucket, copy, lots of photos. And Mr. Bose actually just informed me today that many of those photos are still up on Photobucket as of this morning.
I'm sorry, many of them what?
They're still up on Photobucket as of this morning.
Actually, about 20 minutes ago when I walked over here.
So these photos are in the public domain. I don't think there's any secret about these photos, what they show, and the Sentinel does have copies of these. So to a large extent, any order might simply be ineffective because the Sentinel already has them. But in the McCrary case, the Florida Supreme Court was clear about the standard that should be applied by Your Honor when considering that, and that's the Lewis standard. That the defendant has to show a serious and imminent threat to the administration of justice, no alternatives to closure, and that it would be effective and no broader than necessary. What we heard today from the defense were just conclusory assertions about the fair trial right, but really more so relevancy and privacy. The privacy policy justifications are not enough under McCrary. And again, neither is relevancy. The potential admissibility or inadmissibility or relevancy of this material has no bearing under McCrary. It's simply, would the material itself jeopardize the defendant's fair trial rights? With the photos that are out there in the public domain, I don't think they would. And I don't think that the defendant has met their burden, very stringent burden, under McCrary and Lewis to justify closing these records, which are public records. Once they enter into discovery, they're public records subject to disclosure. I don't think they've met that very stringent standard under McCrary, and we would ask that Your Honor deny the motion. We'd also like to be heard on the other motion. I that was noticed as I was driving over here.
It was
file a motion.
late to the show, so we'll let you intervene on that as well. Let me give
Thank you, Your Honor.
counsel a chance to rebut and move forward to the next motion.
Judge, I think the law is clear. You have, this isn't an issue that falls under Lewis. You have under Rule 3.220 3E the right to restrict this. I don't think anybody's contending that. As far as the images, I'm not denying that there are images up on Photobucket. I've laid out clear. I've seen everything that's on Photobucket, and I've seen both of these discs, and I can represent to the court that there are numerous images, and I refer to images because that's exactly what they are, and I think Your Honor can kind of see what I'm referring to, that basically would impede my client's right to a fair trial. I think anywhere we can restrict irrelevant information from possibly affecting her right to a fair trial, it should be done. Where's the harm here? There is no harm, and what's the most significant aspect of it all is we're playing with fire when we're playing with the right of a fair trial. And I think any errors in judgment should go on the side of getting a right to a fair trial, because regardless of what any Florida cases say, the U.S. Supreme Court has made it clear that the right to fair trial is the most fundamental right and should be protected at all costs.
Okay, let's go on to the next motion. It's the motion for the stay regarding release of discovery. I think this goes to recording made at the jail, correct?
Correct, Judge.
Go ahead. And the Sentinel is going to intervene on this as well, so I'll allow you to be heard. Mr. Myers, go ahead.
Yes. Judge, thanks to another one of our reliable leaks at the Orange County Sheriff's Office, it has come to our attention that there is a video that exists of my client being taken to a medical office at the jail for the purpose of recording her reaction to the finding of remains, which ultimately ended up being her daughter. I just wanted to, if Your Honor looks at my prayer for relief, it really is more of a motion to stay until we could have the proper hearing. I filed this more of along the lines of an emergency situation because there are several issues that may come up, and I think I should make the court aware of what these issues may be. First of all, on December 11th of last year, early in the morning, after our appearance in court, when I got back to my office, I received a phone call from Detective Allen, Sergeant Allen. He had informed me that remains were found very close to the Anthony home, and that he was trying to reach both George and Cindy Anthony to inform them of this. Around this time, the relationship between the Anthonys and law enforcement, I don't want to use the word somewhat strained because I can't speak for that situation, but obviously law enforcement was reaching out to me to try and reach out to them to notify them.
Your Honor, if I may, I would like to object to his speech about the relationship between the Anthonys and law enforcement. We're straying from his motion, which is to stay the release of this videotape.
I just qualified
and ask that we could narrow the issue.
I